Hello and welcome to part two of this summary of our 13th annual Employment Law Breakfast Briefing. If you've already watched part one, you know what this is about. But if you have skipped through to part two, just to explain, this is a summary of an in-person event we ran in January 2025, summarising some upcoming changes. And my name is Ian McRae and I'm an employment partner at Field Seymour Parks. So what are we talking about in this session? Part two. We will be talking about what you need to do to prepare for day one rights and some changes to leave. Do you have to agree to flexible working requests now, which comes from this idea that flexible working is now the default? We'll sort of explore whether or not that's true. What more do you need to be doing to prevent harassment of your employees and workers? And what does the right to switch off really mean? So that's what we're covering in this part two. Let's start by talking about day one rights. So the focus, day one rights means lots of things. It means lots of employment rights that you get from day one of employment. But the focus for this session is really on unfair dismissal rights. And to highlight what is changing so that you're aware of the impacts upon you and what you might want to be thinking about doing now. So the current position for unfair dismissal, in very simple terms, is if you want to bring an unfair dismissal claim as an employee, you need 2 years service unless that dismissal is automatically unfair. So things like health and safety, whistleblowing, etc. Employment Rights Bill proposes some changes to that. We are told it's not going to come into effect before autumn 2026. And in very simple terms, what it is saying is there will be unfair dismissal protection from day one, but there will be a modified process if the employee is dismissed in an initial period or statutory probationary period, call it whatever you like, or notice is given in that initial period, and the termination then occurs within 3 months of the end of that initial period. So you've got a timing requirement. You also have a reason for that dismissal requirement. So it would have to be by reason of capability, conduct, statutory restriction, or some other substantial reason relating to the employee. So if it is in or relates to that initial period, if the reasons stack up, you have this modified process. Lots of question marks there, which I'll cover in the next slide. The things that we can say is, as it currently stands, is that that's not going to apply to redundancy. It's highly unlikely to apply to reorganizations, and it also won't apply to changes in terms, all of which would be a full unfair dismissal process on day one. So questions and issues. First thing to flag is that if that modified procedure applies, as I've set out, you don't have to give written reasons for termination. You would in other circumstances. But then the questions. What is that initial period? What is that statutory probationary period going to be? We don't know. We know the government's preference is for 9 months. In the amendment paper that was published, the Employment Rights Bill, that talks about 3 to 9 months. So it looks at 9 months being the outer end of that potential scale. The modified procedure, we don't know what that is either. We know it is going to be lighter touch and less onerous. And there is some sort of suggestion there would be at least some form of meeting required to explain concerns to the employee. But we don't know much more than that currently. We know that the government thinks that there should be a reduced level of compensation for a breach of the modified procedure as opposed to a normal sort of unfair dismissal claim. But there's a lot of uncertainty, and obviously this one isn't due for a fair period of time. There are a lot of potential issues with as it currently stands, and we'll have to see if the government irons these out as it progresses through Parliament. Big one, full redundancy protections on day one, which would mean that if you had just employed someone and you needed to run a redundancy process, they would need a full process to give effect to a fair dismissal in the same way as an employee currently is required when they have 2 or more years service. You have this potential issue, a bit of an extreme scenario, but you could have someone who is employed for a single shift on a fixed term contract, so working for a single day. An expiry of a fixed term contract is a dismissal, so potentially it's an unfair dismissal. Your reason for not renewing that contract, aka the dismissal, is probably redundancy. I'm assuming you don't need them after that single shift, in which case you'd have to follow a full redundancy process from day one. We wait to see if that little scenario is resolved by the government. We'll talk about in the final session, in part 3 of this recording, that 0 hours contracts are becoming more, or are likely to become more, onerous for businesses. Does that mean that we have more employees rather than workers, and therefore more risk of unfair dismissal claims? If things go through as currently planned, I think you might see more constructive unfair dismissal claims, employees choosing to resign in response to how they've been treated rather than waiting for them to be dismissed, particularly if a fair dismissal could be enacted via a short form modified procedure. We don't know what that modified procedure is. There is a risk it will create greater uncertainty. We have a settled set of case law relating to unfair dismissal claims. With a new process, you may need some cases to fully determine exactly what is required from employers. One of the selling points of day one unfair dismissal rights was that it might reduce the number of discrimination claims. Currently, the suggestion is that some employees will pursue discrimination claims just because that is the only thing open to them, because you don't need any length of service for a discrimination claim. However, if the modified process has a capped level of award, you might still end up with those more complex and difficult discrimination claims being brought forward. And does it lead to more risk-adverse recruitment? So, action points. Well, this is a little fair way off. The things I would be really thinking about now and this year is obviously tracking what happens and what the plans are, but I would be thinking about real clarity of roles and expectations in your organization. So whether that is job descriptions, whether that is competency frameworks, whether that is policies, whether that is working hours, hybrid working, home working, dress code. If you are going to have to manage people from day one, the only way you're going to be able to do that successfully is if you are crystal clear from day one in terms of what the expectations for that role are. The other thing I would be looking at this year is your recruitment processes. If you've got complete clarity of what you want from your employees, that should then be able to feed into your recruitment processes, and you can try and make sure that you are getting those decisions right with respect to the skills, experience, standards that you expect. In due course, and when we have more information, you're going to need to be thinking about training and management. You might be looking at your notice periods. If that modified procedure is onerous, will you want as long a notice periods as you currently offer when you're going to have to follow some form of process beforehand? Depends what's involved, one to watch. You can have separate contractual probationary periods to what is what the government determines to be the statutory probationary period, this initial period where the modified procedure applies. But is that going to be too complicated? Would you rather just have one set period of time? Something to think about. You're going to need to track length of service a little bit more carefully than you do now. And depending upon how this is enacted, it is possible that the people you are employing now will qualify for full unfair dismissal protection quicker than you would normally expect. So they'll be getting there before they hit 2 years service. And ultimately, you're going to be looking to proactively manage this so that you don't have a number of last-minute exits, particularly before the legislation comes in. So, something slightly different. New leave entitlements. There's a few things to highlight here, which I will sort of rattle through so that you're aware of them and can look into the details. One that we definitely have coming in, and we definitely have coming in this year, is neonatal leave and pay. And this will apply for babies born on or after the 6th of April. And if you are a parent, an intended parent, so dealing with surrogacy scenarios, or a partner to a mother, and your baby unfortunately requires neonatal care in the first 28 days for at least 7 consecutive days, then you may qualify for neonatal leave and pay. Neonatal care includes care in a hospital or under the direction of a consultant outside a hospital, or palliative or end-of-life care. The leave entitlement is up to 12 weeks, but it is linked to the length of time that the child is in receipt of care. And the leave is going to be a day one right. The right to pay is still going to be service linked. So you need 26 weeks service for that, and it's at a statutory rate, so not at full salary unless the employer chooses otherwise. The idea is this leave will be taken in the first 68 weeks after birth. So there will be two types of leave. For most people, it will be what they're calling tier 2 leave, which will mean that when your child is undergoing this care, you're probably on some other form of family friendly leave, like maternity leave. And in those circumstances, you will add the neonatal leave on to the end of your maternity leave and take it as one block. And you would need to give 28 days notice that you want to take that leave. Alternatively, if you're not on family leave for whatever reason at the time the child needs that care, then you can take it in non-continuous blocks of a minimum of 1 week, and you have to give 15 days notice. So slightly different notice requirements depending upon when it is taken. Right, some other leave changes which are slightly more speculative, or we're not so sure on the timeframes of it. So the Employment Rights Bill includes a removal of the 26-week qualifying period for paternity leave. The Conservative government passed but the Paternity Leave Bereavement Act, one of the last things they did before obviously losing power. But that requires some regulations for that to be enacted, and that is some further changes to paternity leave, in particular opening the door where the partner to a mother unfortunately has the mother pass in childbirth. There's a potential through the regulations to maybe allow them to increase that leave requirement to 52 weeks rather than the normal 2. A new right for bereavement leave, that's in the Employment Rights Bill. That would be a day one right, 1 week unpaid leave. We wait to see who that will apply to, so which sort of family members that would qualify for that sort of leave. It is assumed that it's likely to be spouse, civil partner, parent, or someone in the same household who is not a lodger, employee, etc. Haven't put a child on there. The reason being is there obviously is already a right to 2 weeks paid leave on loss of a child. Unpaid parental leave will become a day one right rather than requiring a year's service. And there is the potential for a wider ban on dismissals when returning from family leave. You will be aware of the protections that are already available from dismissal by reason of redundancy. There is a suggestion that could be widened out to cover other forms of dismissal. As always with leave, you need to update your policies, so you need to be getting a move on with that neonatal leave policy, updating any templates, and ensuring your managers are aware of the rights employees have. So, something slightly different. Do you have to agree to flexible working requests now? And the reason we get asked this question is there was a lot of publicity about flexible working now becoming the default. And the bold italics writing is a quote from the Labour manifesto, which is where it will become the day one for all, except where it's not reasonably foreseeable. So what's potentially changing? Well, it's been a day one right since the 6th of April 2024. You've still got the same 8 statutory reasons to reject a flexible working request. That is still planned to stay the same. However, you'll only be able to rely on those reasons if it is reasonable to do so. You state those grounds and you state why it is reasonable. Remedy for getting it wrong is still 8 weeks pay at a capped rate. And this is in the Employment Rights Bill, so we don't know yet when this will be introduced. But what I would suggest you might want to be thinking about now in anticipation of these changes is just ensuring that your policies and practices are, as far as you can demonstrate, they are reasoned and evidence-based. So things relating to hours of work, relating to hybrid working, relating to in-office attendance, you might want to make sure that you have already thought about how you are going to justify those policies now, rather than waiting for more flexible working requests to arrive in due course. Preventing harassment. So, as of the 26th of October 2024, which I would have talked about in this session this time last year, employers have a new obligation to take reasonable steps to prevent sexual harassment of their workforce, and there's a potential 25% uplift to claims if they fail to do so. We have some further changes to that, though, envisaged by the Employment Rights Bill. First one is that instead of it being reasonable steps, it will become all reasonable steps. And importantly, it will mean that there will be liability for third-party harassment, so clients, customers, suppliers, business connections, unless the employer again took all reasonable steps to prevent it. And in short, that is going to be a very high bar. Employers are really going to have to be able to demonstrate that they have really thought and applied their mind as to how they're going to protect their employees. The other thing I should say is that reporting sexual harassment will become a protected disclosure. That will mean that if someone makes a protected disclosure, they are protected from dismissal as a result. They're protected from being treated less favorably or subjected to a detriment as a result. It also has a knock-on impact on settlement agreements and NDAs. A lot of you will be familiar with a carve-out in the confidentiality clause of those agreements relating to protected disclosures. So that would cover sexual harassment disclosures in due course. And I'm aware a further specific amendment has been added into the Employment Rights Bill to deal with, to try and ensure those agreements won't prevent employees being able to talk about allegations of sexual harassment. If you haven't already done so, you need to do some work on this. The key things are doing a risk audit of your organization and having a paper trail to show you have done that. And then you have put in place the policies and training that are required then to reduce those risks. I would also start thinking about how you can protect your employees and workers from third parties now, because that is not going to be quite as straightforward. There's all sorts of things you can think about there, including contractual changes, notices, policies, training, all sorts of different things. We have helped a number of employers with this in respect of sexual harassment, and we're helping a number of others prepare for this wider obligation as well. So if you're in any doubt as to what to do, please do get in touch. We're happy to give you some pointers. Other discrimination changes, well, those large employers, so 250 plus employees, will already be familiar with doing their gender pay gap reporting. That will now need to be accompanied by an equality action plan dealing with how they're going to promote gender equality, reduce pay gaps, support employees going through the menopause, and preventing sexual harassment. It is also likely to require them to provide information from outsourced service providers. So if you are providing services into one of those large employers but don't meet the threshold yourself, you may find that they are requiring information from you so they can comply with their obligation. We also have a draft Equality, Race and Disability Bill that is being proposed. This is likely to move more slowly because the Employment Rights Bill is being treated as the priority, but that is potentially going to cover equal pay for ethnic minorities and disabled persons, and ethnicity and disability pay reporting, again, for those larger employers. So, last thing in this part 2, what does the right to switch off really mean? Well, this is not in the Employment Rights Bill. What is proposed instead is that there will be a statutory code of practice prepared. The likelihood is that then failure to comply with that code of practice will lead to a 25% uplift in associated claims, and equally a failure to comply with that code could be used as evidence in support of another claim. For example, a constructive unfair dismissal claim for asking an employee to work unreasonable hours. The onus is likely to be to agree a policy for your workplace. So instead of it being a one-size-fits-all, it's likely that that code of practice will require employers to consult with their employees or maybe with a union in respect of what that policy should be for that workplace, covering the types of things I've put on that slide. What should you be doing about it now? Well, I think you just need to be thinking about the potential impacts upon your business. You might want to be looking at tracking or auditing how often people are routinely working outside normal hours. What sort of culture do you have on communications outside those normal hours? What then is the expectations? Making sure you've got clarity of that. You can, of course, obviously prepare a policy now in anticipation of that, which would be good business practice. Already talked about in part one, national minimum wage obligations and indeed working time regulation obligations to have some idea, more than some idea, of the hours your employees are working. And if you are keen to embrace this, there are all sort of practical steps that you can take to try and ensure that you are promoting that right to switch off. So, normal conclusion at the end of this session. This is obviously a very brief summary of some of the changes that are due. And please do take legal advice on your own specific circumstances. We would, of course, be happy to have a chat about any questions or concerns that you might have. If you haven't already done so, please do subscribe you can drop me an email and we will make sure that we send you details of our future webinars, updates, and further events that we'll be running, particularly as some of the details of these changes comes through in due course. Thank you.